executive orders that have been promulgated by the governor, as well as emergency administrative orders that have been issued by Chief Judge Barbera. This is a new procedure for this court, and we hope that you will be patient as we move through this new electronic era. Our intent is to allow the litigants through their counsel to proceed with the appellate process and to continue to administer justice through this very difficult time for our court, our state, and our nation. Since the court is new to using this technology for oral arguments, we do expect that there will be some hiccups. And so if you are experiencing technical difficulties, please raise your hand so that we will know that there is a problem or an issue that we need to address. And we will do the same if we cannot hear you. If somehow we get disconnected, please wait 5 minutes and attempt to rejoin the call. Now, the time limitations have been requested, and we will stick to those. The clerk of the court will put up a sign to advise you of the remaining time for your argument. So please try to look up so that you can see the time that he is indicating on the charts. As well, I would indicate for those of you who are not on mute during your argument, please understand that sometimes papers or other pens or objects on your desk or right in front of you, if you move them, they may result in some unpleasant noise for all of us. But as I said, we understand that this is a new process for all of us, and so therefore we'll all seek to be patient with one another. With that, I think we are ready, and I just wanted to say that for our purpose, normally the clerk of the court will advise you whether you have 5 minutes left, 2 minutes left, and 0 means no minutes left, and you must finish your sentence. With that, I think we're ready. We have 4 cases scheduled on the docket today. And the first case is Ernest Maxey versus Lockheed Martin, and it's number 2956, September term 2018.
Your Honor, may I begin?
Yes.
All right, thank you. Good morning to this honorable court, to the clerk and to counsel for the appellee. Your Honor, I come here today to ask the court to reverse a finding of summary judgment for the appellee. And the request is based on the fact that the finding of for the appellee on the basis of this record was not correct, because there are very genuine, very serious issues of material fact in this case, which has essentially one issue. That issue being is whether or not on August the 7th of 2014, the appellant was discharged wrongfully by the appellee, the Lockheed Corporation. The appellant is a gentleman by the name of Ernest Maxey. He was hired by the appellee in 2010. He was operating in a war theater at a Marine base in a war zone in Afghanistan. What he did was, I don't believe that is in dispute that on August the 7th, 2014, that he was operating satisfactorily. He was getting good reviews. There were no problems by the employer appellee against him. But on August the 1st, first of all, on June the 30th of that same year, 2014, he reported to his employer that some of his fellow employees were in violation of the policies of the employer. They were in violation of American law and Afghanistan law, and in violation of military policy. And the violation.
You've indicated that he was discharged or he was terminated. Didn't he resign?
No, well, he did resign on August the 19th. However, he was terminated on August the 7th, which was approximately 8 days, if my math is correct, about 12 days before that. So that when he submitted a formal resignation on August the 19th, he was doing that simply to try to preserve his security clearance, but he was no longer an employee in any indicia of employment. And that is on August the 7th, his medical insurance, his vision insurance, his health insurance, his dental insurance had all been canceled. He had been removed from the list of employees. His access to the put in time had been ended. He was no longer able to use his email. His credit cards had been canceled, and he had been sent home. And actually, he hadn't been sent home. He had been placed on a plane in the early hours of August the 7th and dropped off in the Emirates of Dubai. And when he tried to use his company credit card, he learned that it had been canceled. And not only had the card been canceled, but everything else had been removed him from the system as an employee, those things that he had relied upon.
So, counsel, even if Mr. Maxey was discharged from his employment as opposed to him resigning voluntarily, what evidence in the record supports a finding that the discharge violated a clear public policy mandate?
Well, it's not only under Maryland law, the strongest policy mandate would be if you are asking the employee to commit a crime, or if the employee is reporting a crime and he's terminated for reporting a crime. It is not disputed, if you look at the appellee's brief, it is not disputed that the use of alcohol and marijuana in the military theater in Afghanistan was a crime against United States law, a crime against Afghan law. It was a violation of company policy, and it was a violation of the military policy. And as Mr. Maxey reported to both his employer and to the military commander, the report to military commander occurred, I will add parenthetically, on August the 1st. This had severely degraded the war effort that the United States was engaged in Afghanistan. So the public policy is that an employee who reports criminal activity to the employer should but not be terminated because the employee is reporting that criminal activity. A report of criminal act, there's a public policy in the state of Maryland that employees should be encouraged and protected when they report criminal activity occurring in the employment. And so so to answer the question, Your Honor, it was the reporting of criminal activity that was the public policy that was violated by the employer.
So on what statute, constitutional provision, judicial decision, regulation, or other potential statement of public policy is that clear mandate based?
It was based on Maryland law, Your Honor. I would just,
what aspect of Maryland law?
It's Maryland judicial common law that I guess there's two parts. First of all, I think we're all in agreement that a terminated employee for if the termination of the employee violates a clear mandate of public policy, that is a wrongful termination. I think that the court is not asking that. But as I understand your question, Your Honor, you're asking me what is the basis of my argument that reporting criminal activity violates a clear public mandate.
Correct. Is it based on a statute? Is it a constitutional provision, a judicial decision, regulation, or some other pronouncement of what public policy is in Maryland?
Okay, I would say it's based on the source would be the primary source would be court decisions that public policy includes asking an employee to commit a crime, or an employee refusing to commit a crime, and an employee reporting criminal activity.
But counsel, in this case, we're not confronted with the employee, your client, refusing to commit a crime, because your client admitted that he also was committing these crimes, at least with regard to alcohol.
Yes, that's certainly a valid point. But that admission came in an interview with the military, and that admission of this criminal activity was not known to the employer until after he had been terminated. So it was not a factor in the termination. And that's part A to answer. Part B is that the employee, when he made that admission that he had engaged in this, he also stated that he had ceased. First of all, he never admitted to the use of marijuana. There's no credible information before this court that he did. And secondly, his use of alcohol had ended in March of 2014 when he made this report to the employer in June the 30th. He was making that report because although he had stopped, his fellow employees had continued this activity, and he wanted the employer to know that this was having a deleterious effect on the war effort. And so the fact that he had engaged in this behavior was not a factor as to what happened on August the 7th, because there's no evidence to suggest that the employer was aware of that activity at that time when the employer summarily removed him from employment.
So, counsel, to what extent is the public policy analysis from Yuan v. Johns Hopkins University distinguishable from the analysis that we should be applying in this case?
I don't believe, Your Honor, that it is distinguishable. I think it is helpful. Again, the question before the court is there a public policy exception to terminating an employee at will? The case law says yes. And so it can't be reasonably argued that an employee who reports criminal activity in the workplace to an employer is within the public policy of the state to encourage, because employees, if there is criminal activity that is occurring, that criminal activity clearly is a detriment not only to the employer, but to the general public. If an employee is discouraged from reporting crimes, then that would be injurious to the employee, it'd be injurious to the company, and it'd be injurious to the citizens of Maryland. We want citizens to report criminal activity. We don't want citizens to feel that if they perform their civic duty of reporting crime, that they have to make a decision as to whether they're going to keep their job or perform the important civic duty of reporting criminal activity.
So if Mr. Maxey was discharged from his employment with Lockheed Martin, what evidence in the record supports a nexus between any activity on his part and the reason for his discharge?
Your Honor, two very important nexuses occur. And I would say that the issue, first of all, I would say that whether there's a nexus is a trial issue, not an issue for summary judgment. It's a matter because he's entitled to the inference of a nexus at this stage. However, to answer your question directly, the timing, he makes the report on August the 1st, he's terminated on August the 7th. So that's 6 days. Number two, prior to him making this report to the military, he was an employee in excellent standing. So the only thing that changed between, let's say, the end of July and August the 7th was that he reported criminal activity. He was terminated right after that. So it is a reasonable inference that absent some other fact or circumstance, that the two are connected. And I'll give you an example, Your Honor. In EEO law, if an employer takes an adverse employment action against an employee within 6 months of that employee engaging in a protected activity, and this is a protected activity, reporting a criminal act, that 6 month period is deemed to provide a nexus. We're not talking about 6 or 5 or 4 or 3 or even a week. We're talking 6 days. So it is very straightforward that the 6-day period between the reporting of the crime and the termination certainly gives a jury a basis to find, a reasonable basis to find a nexus. And we would ask the court not to engage in the fact finding of whether there was a nexus, but to leave that to the province of the jury.
So, counsel, if I understand your argument, what you're saying is, in effect, timing is everything, and that the sequence of events and the dates on which these matters occurred is a basis from which a fact finder could reasonably infer that there was a connection between your client's reporting this misconduct and his termination?
Your Honor, I don't say timing is everything. I say timing is one of the important factors. The other factors regarding his termination would be.
I don't want to interrupt you, but I don't know whether you can see the clerk's sign. It says you have 1 minute left for your argument. Obviously, you can go over into your rebuttal time, but I just wanted to let you know that because on my screen, you're frozen.
Okay, well, I can tell you, Your Honor, yeah, I do have a timer here, and I do.
Okay.
I do have about 40 seconds left. I would just say to the court that the jury's province is to look at the timing, to look at the circumstances, to look at all these factors. And I would say that when you look at the judge's ruling, the judge invaded the province of the jury to make it a decision that there wasn't a nexus, and the judge invaded the province of the jury to make a decision that my client resigned and was not terminated. Whether that is in fact the seminal issue did he resign on the 19th? Did he resign? Did he resign because of a debarment letter which he did not receive until the 12th, or was he terminated on the 7th when he was shunted out of the theater and dumped into the bar alone? So that concludes my argument for this time.
Judge Keough, do you have another question for him?
No, I just wanted to tell Mr. Hilton that I lost Mr. Abdullah's video about 10 minutes ago. I didn't want to interrupt because his audio was coming through loud and clear.
That was the same for me as well.
We've had this issue we think it's a bandwidth issue. At this point, unless the court wants to reset everything, we can just proceed.
No, I heard everything. Judge Robinson, did you hear him as well?
I heard everything.
And
as did I.
Counsel,
I did as well, Judge Shaw-Jeter.
Okay. Did you hear him, counsel?
I did.
Yeah, Your Honor.
Okay.
Oh, I'm sorry.
I think it's fair. We can proceed then with argument. Everyone could at least hear each other, even though we may not have been able to see each other. So I think we're good. All right. Are you ready to proceed, counsel?
I am. Thank you, Your Honors.
Thank you.
The public policy exception to employment at will, as this court is well aware, is a very narrow exception. It requires proof of 3 elements: that the employee was discharged, that the basis for discharge violated a clear mandate of public policy, and that there was a nexus between the violation of public policy and the discharge. The plaintiff in this case is unable to meet any of those 3 elements of the cause of action. First, and this was addressed in some of the questions of Mr. Abdullah during his argument, there's been no identification of a clear mandate of Maryland public policy. Under decisions of Adler and Hooley and Huron, we need to be looking to see whether there is a constitutional provision, a statute, a regulation, or a judicial decision. And the claims in this case fit into none of those categories. What we're talking about here is the law of Afghanistan and a United States military order with respect to the conduct of employees in a war zone. Now, Mr. Abdullah, a couple of times during his argument, mentioned U.S. law. There's been no citation to any U.S. law that's implicated in this case. What we're talking about here is, one, the law of the country of Afghanistan, and two, a general order issued by the United States military for the conduct of contractors operating in a military zone.
Why wouldn't encouraging employees to report illegal activity in the workplace be considered a clear public policy mandate?
Well, I think in that respect that there is a parallel with the decision in Yuan and the decision in Parker. And what the court addressed in those cases were schemes where another agency had authority to resolve and address problems in the workplace and had a particular expertise with regard to the issues that were raised. I think that there is a parallel here with regard to the United States military's ability to establish what rules should govern the workplace in a war zone and why, and to enforce those rules. Now, here, the military determined that Mr. Maxey, as well as 4 other employees who were engaged in the activity of alcohol and, for some people, marijuana, were going to be debarred, and that they were not going to be permitted to return to Afghanistan for a period of 1 year. Mr. Maxey had the ability.
Counsel, was that all that clear? If you accept your colleague's argument that his client was terminated on August 7th, were the facts supporting Mr. Maxey's debarment known to your employer at that time? What in the record shows that?
Well, this is an argument that I don't think was made in the past with regard to Lockheed Martin not being aware. Mr. Maxey testified in his deposition that he told Lockheed Martin, as well as telling the military investigators in the CID, that he himself had violated the general order and the laws of Afghanistan by the consumption of alcohol and the receiving alcohol in the mail and distributing it to other employees. Since Mr. Maxey departed on the 7th, that communication to Lockheed Martin must have occurred at some point prior to that time.
Yeah, but that's all, but in terms of the decision, if you characterize what happened on the 7th as a termination, isn't that information after the fact, after your client decided to terminate him?
I'm sorry, Your Honor. I'm not sure that I understand the question, but perhaps I also wasn't clear in my answer to the last question. And that is, Mr. Maxey in his deposition said, I told Lockheed Martin that I had violated the general order and I had violated the laws of Afghanistan.
When in the deposition, or not when in the deposition, did Mr. Maxey give a specific time that he told the employer, and was that before or after August the 7th?
He did not give a specific time. My point is that since he departed on the 7th, that the communication must have occurred prior to that point in time.
Is that I see where a fact finder could easily draw that inference, but is that the sort of inference that can be drawn in your client's favor in the context of a summary judgment proceeding?
Well, Your Honor, I don't think that inference even needs to be addressed in the context of the summary judgment because of the subsequent written resignation that was submitted by Mr. Maxey. Now, we contend that Mr. Maxey resigned orally on the 7th, but there's no question that Mr. Maxey submitted a written resignation on August 19th. And that was after he received the debarment letter from the U.S. military. And I asked Mr. Maxey in the deposition whether he had been told by anyone at Lockheed Martin prior to submitting that resignation letter that he had been terminated. And he said, no one ever told me that. Now, he says he has reasons for submitting the resignation because he wanted it to be a resignation and not a termination to protect he thought to protect his security clearance. But the fact remains that his testimony in the deposition is that he did this voluntarily, that no one told him he was terminated before that point. So I think that stands as an undisputed resignation from his employment.
Now, I don't want to try to put words in your mouth, but are you saying, in effect, that his resignation with the background that the factual background that you just summarized, as it were, trumps whatever renders irrelevant whatever arguments that your colleague has made to us with regard to the circumstances of what happened on and before August 7th?
That's correct, Your Honor.
I understand. Okay. You go ahead.
That the court need not address that issue. Now, back to the question of whether there's a clear mandate of public policy. I think two things. It's suggested in Adler that the public policy exception doesn't apply extraterritorially. Now, what we have here is no connection with the state of Maryland. The plaintiff didn't work in Maryland. The plaintiff is citing no Maryland statute or constitutional provision. The only connection that this case has with the state of Maryland is the fact that Lockheed Martin is present in the state of Maryland. So in terms of what Maryland public policy is at issue, I would say that the plaintiff has identified no public policy and that the expertise for determining whether there's been a violation of the general order of the U.S. military or the laws of Afghanistan is, as a parallel to the Yuan decision, properly left in the hands of the U.S. Military. And Mr. Maxey could have appealed from the debarment order, but he chose not to. Apparently, because he had already admitted that he was in violation of the order. Not only was he using alcohol, but he admitted that he was getting it through the mail and distributing to other employees.
Well, let's say that, public policy should be that employees are able to basically tell on other employees who are engaged in bad conduct, illegal conduct, what have you. But what effect would that public policy have when the person who is telling on the other employees is a participant and is actually a distributor?
Exactly, Your Honor. And I think here we have a parallel to the Jackson case, where the court held that the reporting needs to be made in good faith. And here, there's the issue of Mr. Maxey was a prime participant. He says he had stopped the behavior sometime before the time that he did the reporting, but the fact remains that he himself had admittedly committed a violation, not only as a user, but as a distributor. And as such, in both his communication to the CID and in his deposition, he acknowledged that he understood when he was making the report the consequences that he was facing. And he said this specifically in his communication with the military before he departed from Afghanistan. And I asked him in this deposition, do you expect to get a pass on your own violations of the policy because you did the reporting? And he said no. And I think under the Jackson decision, that's one of the primary issues that we have here. We don't have a case here of an innocent employee who's making a report and is subsequently terminated. We have someone who was a participant in the behavior and, in fact, one might say a leader in the illegal behavior making a report. He can't immunize himself from the determinations of the government as a consequence of making this report.
Counsel, you referred to the lack of extraterritorial effects with respect to the claim for wrongful termination. How does the cited portion of the Adler decision support that proposition?
Well, Your Honor, I think that the language there referring to the fact that in that case where a public policy was found that it wasn't talking about having an extraterritorial effect. And I think that...
But wasn't that in the context of the court stating this does not offend federal sovereignty nor the federal constitution, nor does it have an extraterritorial effect?
Yes, that's absolutely correct, Your Honor. And I would say here that that is a parallel consideration of what we're talking about is not interpretation of Maryland laws, but we're talking about the interpretation of the laws of another country and an order of the United States military. And in that respect, that's the basis of our argument that the public policy exception should not be applied, and that language in the Adler decision supports that argument. I think two things that's important to remember in analyzing this case before I move to the trial court's reasoning. And one is that Mr. Maxey, who was the reporter, was treated exactly the same as the other 4 employees who didn't report and were found by CID to have been involved in the prohibited conduct. All of the employees involved were debarred. All of them are removed from Afghanistan as they needed to be. And second, related to that, I think it's very important to remember in analyzing this case that with regard to removing Mr. Maxey from Afghanistan, Lockheed Martin didn't have a choice. Lockheed Martin couldn't say, United States military, we disagree with you. We're going to keep Mr. Maxey here. This was a decision by the military pursuant to their rules about how to conduct activities in war zone. And as a consequence, to a large extent, actually to a conclusive extent, the question of whether Mr. Maxey could stay in Afghanistan and continue to perform his job was out of the hands of Lockheed Martin. And that's what Mr. Maxey was hired to do. He was hired specifically to work for Lockheed Martin in Afghanistan. That's the only place that he worked for Lockheed Martin, in Afghanistan. Not in Maryland, not in the United States, in any other location. Now, with respect to the trial court's determination that there was not a nexus, I think that the trial court was absolutely correct in making that determination, and primarily for the reasons that I just stated. There's absolutely nothing in the record to suggest that Mr. Maxey, as someone who made a report, was treated differently from the other employees who were found guilty of the offenses but did not report. Second, Lockheed Martin, in removing Mr. Maxey from Afghanistan, had no choice about letting him remain there. It was required to comply with the orders of the U.S. military. And Mr. Abdullah points to nothing in the record other than timing with regard to making a nexus. And his argument about timing, I think, one is not supported by the facts in the record. And second, doesn't overcome all of the other indications that the termination had at the removal from Afghanistan, and then the rest had nothing to do with Mr. Maxey being a reporter, whether it was pursuant to a resignation or whether it was, as Mr. Maxey argues, a termination on the 7th despite the fact that Mr. Maxey testified clearly in his deposition. He was never told before submitting his written resignation that he had been terminated from Lockheed Martin. Mr. Maxey has made other arguments in his brief with regard to the order denying his application to extend the time to file an out-of-time opposition to the summary judgment motion. We've addressed that fully in our brief, and I think the fact that the trial court held an extraordinary more than 3-hour argument on this issue, during the course of which Mr. Abdullah was permitted to address all of the arguments that would have been presented in the summary judgment brief. I think that even if that were error, which we submitted was not, it would be harmless. A second, appellant did not preserve his right to appeal from the denial of the motion to extend because it was not included in the notice of appeal. And finally, there was the issue of counsel wanting to use Mr. Maxey's deposition in a workers' compensation matter during the course of that oral argument. Again, we think that the trial court was absolutely correct in determining that that reference to other testimony could not be utilized by Mr. Maxey to expand or contradict what he testified to in his deposition in this matter. And additionally, as set forth in our brief, the testimony that was referred to in that deposition in no way adversely impacts the trial court's determination that summary judgment should be granted because of a lack of nexus between the reporting and the resignation or termination of Mr. Maxey. If the court has any questions about those additional issues or any of the prior issues, I'm happy to respond to them.
Judges? Very well, there's no questions, so we thank you. Mr. Abdullah, do you wish to rebut? I believe you reserved 5 minutes.
I did, Your Honor. Just to ask if, is that time start now?
Yes.
All right, thank you. Your Honor, I think what the discussion by appellee clearly shows that there were genuine issues of material fact. The most important of was whether Mr. Maxey had been terminated. Second issue with whether he orally resigned on August the 7th. There's nothing in the record that suggests that. And appellee in appellee's brief and argument have not buttressed that assertion. And so because the appellee says that the court was correct in making a determination that there wasn't a nexus, that's precisely why this summary judgment needs to be reversed. The court should not be making determinations. The court should simply state that the records here show this is what happened. The record shows the absence of a nexus, and the appellee is entitled to judgment as a matter of law. No, what the court did was the court says, I don't find a nexus. And the court's statement that it did not find a nexus invaded the province of the trier of fact. And this is what requires reversal. So just to go back with regard to public policy, clearly the appellee in its brief states that there was a United States policy, that is the United States military had a policy that you cannot use alcohol and marijuana in the theater. And it was the Afghan law. So that the fact of the matter is that we had a policy that was issued by the United States military, which is part of the United States government. So we had that, and we do have the violation of that, and we have a nexus that the determination on the 7th happened within 6 days of Mr. Maxey coming forward. Now, the appellee says that they had no choice but to send him home. It is clear from the brief that we have submitted and from the record that the appellee did not learn about the debarment until the 12th of August, and that was 5 days after he had been terminated. They also state that Mr. Maxey had said to Lockheed that he had distributed alcohol. What Mr. Maxey said was that alcohol had been brought in, that he had drank it. He did not say he brought it in, and he did not say that he distributed it. This is a matter of, we have to go to the record and to sort out whether or not that is accurate.
Now, counsel, even if there was a dispute regarding whether Mr. Maxey was discharged and a dispute regarding material facts as to whether or not there was a nexus between any protected activity and the reason for his discharge, couldn't Lockheed Martin still be entitled to summary judgment if the court were to determine as a matter of law that there was no clear public policy mandate violated by any discharge?
If the court were to make the determination that there wasn't a public policy mandate as a matter of law, that the court could do that. But for the court to make that decision, if the court had rendered that decision, and just looking at what the court has to say, that the court states that what the court said is that you have to show that the basis for the employee's discharge must violate some clear mandate of public policy and that there's a nexus. And what the court says, I don't find the nexus at all. There's nothing where the court states that there wasn't a public policy mandate that did not exist. The court chose to say that there was an absence of a nexus. That's where this is distinguishable from what the court has asked. Now, I would say also, because I have a few seconds left, that the other employees were not treated like Mr. Maxey. The other employees were actually given a hearing, and they were terminated after there was a process. Mr. Maxey was not given that. Again, with regard to the use of the deposition was a deposition with Mr. Maxey and Lockheed, and they were represented by the same law firm. It was just different attorney. The fact that a different attorney asked the question is not a basis to say that this matter, this testimony under oath should have been rejected by the court. It was under oath, and it was the same parties. They had an opportunity to cross-examine him, and the court was wrong in not allowing Mr. Maxey. As a final statement, because I see that my time is up.
Yes, time is up.
If I could just have a final statement, I would say that the court, if this honorable court finds that there was genuine issues that the trial court resolved in favor of the appellee, that is improper, that those issues should have been answered and resolved at the trial level with the jury. Thank you very much for allowing me to
Thank you.
address the court.
This case is now submitted. I thank you for your consideration, and we're moving on to the next case. Thank you.
Have a nice
Thank you,
day.
Your Honors.